who's the person doing time? Is it him?
Yes.
Yeah. All right. All right. Can I go?
Yes.
All right. We don't deem it permissible for anyone to take a life unless under war. So how is it that we deem it permissible to take a life through the judicial system? My points affirming the abolishment of capital punishment in the United States are as follows. The capital punishment itself is not an effective deterrent. Capital punishments that have been administered have included innocent lives, and that the death penalty is highly expensive. On the matter of deterrence, the death penalty as current state is to be used for deterrence against murders, but there haven't been many studies to show that show the decreasing crime. In fact, it has been quite to the contrary. Recent studies in Oklahoma and California failed to find that capital punishment had a deterrent effect on the violent crime, and in fact found a significant increase in stranger killings and homicide rates after the death penalty has been reinstated. Furthermore, if we take this to where states most use the death penalty, we see from a New York Times survey that the homicide rate in states with capital punishment have been 48% to 101% higher than those without the death penalty. In our neighboring country, Canada, where the death penalty has been abolished there since 1976, the murder rate has dropped by 27%. While one might say that Canada might be atypical, it is actually far from the truth. We see that from the United States Development Program study that the 5 countries with the highest homicide rates that do not impose the death penalty average 21.6 murders per 100,000 people. The 5 countries with the highest homicide rate that do impose the death penalty average 41.6 murders for every 100,000 people on the matter of innocent lives. To this day, 251 inmates have been exonerated through DNA evidence. This point would go to the advocate's benefit if it wasn't for my opponent's benefit, if it wasn't for the simple thought of how many more could have been saved through DNA evidence, as the development of exonerations through it has only started to occur since 1989. And while DNA evidence has been a recent breakthrough, there are current problems with the justice system itself that disallow innocents from being heard post-conviction. As Chief Justice Rehnquist detailed, that claims of actual innocence based on newly discovered evidence have never been held to stated ground for federal habeas relief absent in an independent constitutional violation occurring in the underlying state criminal proceedings. This basically states that unless the petitioner can show that his rights are violated, the plea of actually being innocent holds no grounds for a hearing. The cases by which this happened are the cases of Roger Keith Coleman and Lionel Herrera. Roger Keith Coleman was a man convicted of murder and had substantial evidence post-trial that showed that he was innocent, but he had an incompetent lawyer who filed the appeal 3 days after the 30-day deadline. This eventually turned into a Supreme Court case by which they were trying to determine whether or not he could be denied an appeal in the Virginia Supreme Court. Justice O'Connor wrote, "There is no constitutional right to an attorney in state post-conviction proceedings. Consequently, a petitioner cannot constitutionally effective assistance of counsel in which the proceedings are held." Lionel Herrera, convicted of murder in Texas, claimed that new evidence available 8 years after conviction showed that he was innocent of the murder and that his brother had committed and confessed to it. His appeal to the United States Supreme Court was denied in a 3-1 decision, and he was executed. The central rationale for the denial was stated by Chief Rehnquist, writing for the majority. The rule is grounded in the principle that habeas corpus sits to ensure that individuals are not imprisoned in violation of the Constitution, not to correct errors of fact. Thus, the only point at which an accused but innocent person has a substantial opportunity to be vindicated is at the original trial. After that, he is presumed guilty through appeal if possible. Their scope is now quite narrow. The cost for the death penalty is exponential, and it costs far more than life in prison without parole. The money saved from the death penalty can be used on so many more things, such as public schools, fixing the roads, and allowing people to keep their jobs. Various state governments estimate that a single death penalty case, from the point of arrest to execution, ranges from $1 million to $3 million per case versus life, at an average of $3 million. Without parole cases costing an average, life without parole cases costing an average $500,000 per case. Specifically in Texas, where the death penalty is the most efficient, in that the highest percentage of cases that seek death penalty actually end with execution. The state still estimates an additional cost of $2.3 million average out per case for the death penalty as opposed to life. Here in California, Natasha Minkster, the death penalty policy director of the ACLU in Northern California, called this recent revisions of the death penalty superficial. Minkster added, in the current state of the state, we're wasting money tinkering with the death penalty system. Minkster suggested that by turning the death penalty to life in prison without parole, the state could save billions over 5 years.